recording this as is the teacher, and it's 4 minutes prepared testimony, 10 minutes follow-up. Let's begin by having the judges introduce themselves to the team, and then students, if you could then introduce yourself to the judges, and our chair of the committee today will read you your question. We look forward to hearing from you. I will unmute, but I'm also your timer. Good luck.
Thank you. We'll introduce ourselves and then have you introduce yourself and your teacher. If your teacher is around, and tell me what school you're from too. I'm not sure if I probably missed that, but my name is Susan Firestone. I'm a retired patent and trademark attorney from Fort Wayne, Indiana.
I'm Mike Miles from Birmingham, Alabama, and I feel like I ought to get to be an honorary Virginian as many times as your school and I have been together, but it always seems to be on Mondays of this weekend. So I'm glad to see you here once again, and it's good to see you.
Good morning, I'm Dan Taubman. I'm a senior judge on the Colorado Court of Appeals in Denver, Colorado.
And you are?
My name is Andrew Park.
I'm Georgia Fryer.
I'm Alexander Mack Turk. We all are seniors here at Maggie Walker in Richmond, Virginia, and our sponsor is Mr. Almschneider.
Thank you. So we have selected today question number 1. The right to vote was not expressly included in the U.S. Constitution of 1787. In your opinion, was the implied right to vote in the Constitution sufficient for the creation of a representative democracy? How did the expansion of voting rights affect the evolution of democracy in our country? Please give examples. And which is the greater threat to democracy, disenfranchisement or fraud? Explain your position and you may begin.
In 1960, John F. Kennedy asserted that the right to vote is the precondition of all of the rights. It is only through the exercise of political power that men ensure that government will protect their right to equal treatment before the law. JFK was right. Voting is the royal road to preservation of other rights. The right to vote was only implied and not protected in the original Constitution. Article 1, Section 2 bases congressional suffrage on the ability to vote for state legislatures, implying suffrage but designating voter qualifications to the states. Article 1, Section 4 allows Congress to alter the time, place, and manner of elections. When combined, these clauses create nauseous uncertainty in the level of federal control over elections.
Colonial governments inherited the British idea that voter eligibility should be determined by property ownership. However, voting in America was more widespread than in England. At least 10% of colonists met voter qualifications, while the British electorate was 3% of the population. After independence, most state constitutions limited suffrage. Virginia's 1776 Constitution restricted the franchise to adult white men who owned at least 100 acres of land. Voting was also structured in a way that empowered slave owners. The 3/5 clause inflated the voting power of states with large enslaved populations.
Even at the time, some recognized that this was not a true representative democracy. Thomas Paine, for example, argued that property requirements weaken the government. When a government excludes people from voting, those people will invoke their Lockean right to rebel. The 19th century brought a wave of attempts to remove property requirements, marking the start of an expansion of suffrage. In Rhode Island during the Dorr Rebellion, disenfranchised citizens fought the elite to force democratic reforms, proving Paine right.
The next major expansion of suffrage, the 15th Amendment, prohibited the denial of the right to vote based on race. The 19th Amendment guaranteed the franchise for women, and the 26th Amendment lowered the voting age to 18. Expanding suffrage has historically signaled a commitment to extending the full rights of democratic citizenship to new classes. The expansion of suffrage in the 19th century for the poor and propertyless reoriented national politics around new issues, like the economic rights of small laborers. Likewise, while the expansion of suffrage for women did not immediately guarantee equality, it signaled their status as equal participants in the political process and bolstered causes that women championed, like child labor reform.
Martin Luther King Jr., like JFK, recognized the importance of suffrage to other political gains. He organized voter registration drives to advance his calls for civil rights, culminating in the Voting Rights Act of 1965. Today, battles over the ballot must recognize the historical truth that access to the vote strengthens countless other rights. Some contemporary lawmakers contend that voter fraud by impersonation is rampant, endangering the value of legal votes. Since 2004, 35 states have used their Article 1, Section 4 concurrent power to pass strict voter ID legislation. 17 states now require photo ID. These laws are meant to curb fraud, but according to the Heritage Foundation, there have only been 1,349 proven cases of voter fraud since 1982.
These ID laws are imposed in the name of securing public confidence, but there's little correlation between confidence in elections and stricter laws. For example, Virginia's 2021 gubernatorial election eased strict voter requirements, eliminating the need for a witness's signature on an absentee ballot and repealing a photo ID requirement. However, polling by CNN showed that 82% of the respondents believed that the vote would be counted accurately. In contrast, accusations of fraud were rampant in Georgia and Wisconsin, states with strict photo ID requirements following the 2020 election.
Instead, these laws deter marginalized voters from the ballot, increasing the opportunity cost to vote, and in extreme cases, entirely disenfranchising people in the name of security. In Texas, new legislation has resulted in 13% of mail-in ballots being rejected, well over the usual rate of 2%. Voters whose ballots are rejected are involuntarily disenfranchised and are rarely able to cure their vote. Modern attempts to protect against fraud and enhance voter confidence instead block access to political power and thus equality. We must take steps to curb these anti-democratic threats.
Thank you. Oh, we have some questions for you. Which do you think is more of a danger for enfranchisement? The actual you've discussed various voter ID laws, or in the removing absentee ballots, or having difficult absentee ballots, such as ones that require specific signatures, or versus gerrymandering. And you explain your answer. Which is more of a threat?
I would say gerrymandering is more of a threat, especially considering the court's recent ruling in Merrill v. Milligan. In that case, Alabama new redistricting plan diluted the power of Black Alabamans from 2/7 of the population, but they were gerrymandered all in one district. But the court ruled that changing the map 8 months before an election would be a violation of the Purcell principle and undermine confidence in elections. So not only does gerrymandering dilute the power to vote, but increasingly the court's rulings on gerrymandering has made it hard to change maps that are a violation of the Voting Rights Act and the gerrymandering standards laid out therein.
I disagree with my colleague. I believe limits on early voting are more dangerous than gerrymandering. If we look to Virginia, it passed the Virginia Voting Rights Act under its Article 1, Section 2 powers, which greatly expanded early access to voting, whether it be early in-person voting or an extension of the time that you could receive an absentee ballot. And that way it opened the vote to more people, and it made polling places less congested, and it lowered the barriers to voting.
Thank you.
I told my friends here before we started this morning that I was going to run a pool on how many times I heard the word Alabama today, and down to and I would complain about it, except you're right on. I told them that some states practice gerrymandering. We've perfected it down here, so anybody that wants to learn how to do it can come. And over the last 2 days, you've talked about voting rights one day and equal protection the other day. And I don't think those two are very far apart. If the Constitution guarantees me equal protection under the law, but if a convicted felon in my state can't vote, and a convicted felon in Massachusetts, if he served his or her time, can, if mail-in ballot time is longer in Virginia than it is here, every time one of those people tries to vote and can't, every time the ballot is rejected when it shouldn't be, has the Constitution failed them to keep their promise that they would be equally protected under the law?
I would disagree that the Constitution has explicitly failed them. I believe the Constitution is mere words, and it is up to the judicial interpretation of that text to really interpret the meaning of those amendments.
I would argue that the federal authorities have failed them. If we look to Article 1, Section 4, and if we couple that with the enforcement clauses of the 14th Amendment and the 15th Amendment, that can be read to give broad federal control over elections, which could then be used to institute voter laws like the Voting Rights Act of 1965, which imposed national standards on the states, and that way we could do away with some disparate state laws that either restrict or open the ballot.
Yeah, I'm sitting here on a panel this morning with one of the finest judges in the country, and I've said that to him in private. But a lot of these judges are politically elected or politically appointed by presidents and governors. But the fact that they can be judicially reviewed, some of these excesses, is that really a guarantee that I'm still going to get equally protected just because some judge that was appointed by the president who's running or by the governor who's running is going to review my appeal?
I actually disagree with my colleague on that point. I believe the court's jurisprudence in cases such as Shelby County v. Holder and even more recently.
That's two Alabama mentions today. Go ahead. Keep going.
Yes, in Shelby County v. Holder and Brnovich, when in Shelby County, striking down the preclearance formula as well as the preclearance jurisdictions under the reasoning that since it didn't apply to the rest of the states equivalently, that it shouldn't be applicable to just the districts outlined in Section 5. I believe that's some flawed reasoning, and it's really a failure of upholding what the Equal Protection Clause truly is trying to uphold, which is equality for all persons, regardless of whatever group they may identify as.
All right. Thank you very much. I appreciate it, Judge.
In your opening statement, you discussed the voting requirements during colonial times. Can you tell us why you think the framers did not include voting as an express right in the Constitution or the Bill of Rights?
Well, I think it was more of a issue of politics. I don't believe the framers thought that the Constitution could be ratified under Article 7 if they did include a national standard to voter qualification, or they created a large federal agency to oversee the election integrity in the U.S. I know Governor Morris of Pennsylvania, he famously proposed a national voting qualification, but it became clear that if there was such qualification instituted, the document would not have been ratified by the states.
And even throughout the early history, even after colonial times, the states often did have really disparate qualifications for voting, not only in the property requirements that they imposed, but some states like Arkansas allowed non-citizens to vote up until 1926. Other states had little to no property requirements. Some states like New Jersey allowed women and Black men to vote. And so there's really, I don't think the framers really saw a way to unify all these kind of disjointed qualifications into one national standard.
Did they not see a way, Judge? I'm following up on your question. I'm sorry. Did they not see a way, or did they know that their way wouldn't pass because they had to get the states to ratify it?
I would say it's more of a functionality issue. It's the same issue with slavery, with the inclusion of the 3/5 clause to appease the southern states in order to get the numbers, the 9 of 13 states to ratify the Constitution under Article 7.
Yeah, thank you.
We're talking about, actually, I'm just going to go a completely different route. You have mentioned ideas on ways to get people to vote, but we have a large percentage of people that don't vote and never vote in our country, and they're citizens in this country and are eligible. They never show up, but they might be registered, they might not. Why do you think that is?
Great question. Great question.
I think a major problem is political misinformation and disillusionment with the political process. Many people truly believe that their vote won't matter, either because they live in a heavily Democratic state and they're a Republican, or because they've been taken in by these lies about electoral fraud, or like a large amounts of illegal immigrants or fraud. And they truly believe that even if they cast a vote, it simply will not matter in the large scope of things.
Furthermore, there are a large body of voters who wish to vote in Puerto Rico, and that further points to the disillusionment in the electorate. Under Article 4, Section 3, Congress has the authority to regulate territories, and this large island territory full of voters who wish to vote, who cannot vote because Congress does not allow them to. It just further fuels this disillusionment in the electoral system.
Susan, I think part of their answer to that question is the most accurate and the saddest thing we're going to hear all day, but I think it's true, I'm afraid. Did the Constitution give me a right to vote, or was I born with it, had it all along? It's such a fundamental right that I had it at birth, and they're just listing it to remind everybody that it's there. The reason I'm asking is that the Constitution, if a document has to give me a right to do something, conceivably it could take it away. So
Well-
did it give me the right, or did I have it? Go ahead.
The right to vote laid out in the Constitution is not a positive right, it's a negative right. So the Constitution doesn't even imply a right to vote. It simply says that your right to vote can't be taken away because you're a woman or because of your race. I believe that the right to vote is fundamental and that it's not given, it's inherent in under like the natural law, philosophy of law.
I disagree with my colleague. I believe the Constitution permits you to vote. If we look to Section 2 of the 14th Amendment, in which a citizen may be disenfranchised for participating in a rebellion against the U.S. or quote for other crimes such as felons, the Constitution empowers the federal government to disenfranchise you.
I think it does too.
Can you tell us what your thoughts are about gerrymandering, what the Supreme Court has decided, and what kinds of gerrymandering exist?
Time.
Oh, right.
Sorry.
Great question, but sorry, Judge.
I'll be happy to give you my
Congratulations.
phone number so you can call me later on and let me know your answer to my question.
He's serious. He means it. He wants you to call. That was great.
You deserve a round of applause.
Right.
Very much.
But we're your judges today, and we're never quite done. So we have some follow-up for you. So one thing, I enjoyed your presentation very much. You've obviously spent a lot of time thinking about this, working with this, and possibly arguing with each other about this and about these various rights and things. And this is not an easy question. How do you get people to vote that have the right to vote? And how do you give people the right to vote that want to vote? I mean, it's really different sides of a similar issue and problems. So you did a nice job. And I judged yesterday with somebody from Richmond, Virginia, and he's a professor at Virginia Commonwealth University. So I'll just give a little pitch for him. Since you're just down the road and teaching, there he teaches, but I enjoyed it. You really took us through nicely the history and brought us up to date. So I enjoyed it, and you did a job well done. Thank you very much.
Thank you.
I echo what she said, and I completely agree with her. It's one of the questions that she asked. Every time there's an election and there's a 50% turnout, and everybody brags that half the people that were, well, you know the rest of that sentence. It makes you shake your head and wonder when they sent their taxes in and they knew they weren't going to go vote. But these echo chambers just absolutely so disillusion some people that it's very frustrating. I want to tell y'all got to quit doing this to Samuel. Y'all string this out all weekend. You're here on Monday. He's a bundle of nerves. Just look at him. You can see him from where you're sitting. He's all keyed up and he's nervous. You know how he is. You know how he gets. So when this is over tonight, and I don't drink, but those of you who are 18, take him out and buy him a drink tonight and let him wind down. Y'all just keep him all keyed up. Tell him I said hello and tell him everything's going to be okay today. Everything's going to be fine. Y'all did great. Thanks.
I think you did a nice job. That you had a good description of the historical changes in regard to voting. I like you're starting with a quote from President Kennedy about the importance of voting. That was good. And I like your mention of the 3/5 clause with regard to voting. And when I asked you about a national, why the framers didn't have a requirement for a right to vote, you mentioned Governor Morris and his proposal for national voting that was rejected. I thought that was very good. One thing that you might have mentioned was the framers' concern about slavery and how that, because of the 3/5 clause, that would have increased, what would have presented a challenge in terms of how and whether to count the votes of blacks, and so that I think that was a factor. I was glad to see that you mentioned clause 2 of the 14th Amendment, because as you know, the Civil Rights Amendments were the first amendments that had an enactment or enforcement clause that said that those amendments could be enforced by federal legislation, and that was good. Finally, I would have liked to have seen more discussion about gerrymandering, because I think that's a very important issue. And there are three aspects of gerrymandering that you might have discussed. One is the one person, one vote. Second is racial gerrymandering, and third is partisan gerrymandering. And if I had had time to ask my question, I'm sure you would have shared your knowledge about that issue. But
That's Marcy's fault. That's Marcy's fault, Judge. They would have.
but overall, I think you did a very nice job, and congratulations on your presentation today.
Thank you. Good luck.
Thank you so much.
Thank you.